which is fine, is 654 and so on. And then I'll play a little sting, and then away we go. Bernard Mostert joins us now. It's good to be seeing you, Bernard. Excuse my rather dark visage here, but we have load shedding here in our offices in Sandton, in Randburg. And as a consequence of that, the usual lights that are on in the studio aren't on today, but you're nice and clear. No load shedding your side of the world?
No load shedding, Alex. It's cold in George, but clear skies, and I'm fortunate that I've got some sun shining down on me, and long may that last.
Well, I'd love to know if the sun is shining down on you after this announcement today from Steinhoff. Just for a little bit of background, you guys own Tekkie Town. It was bought by Steinhoff with, well, shares that were worthless. Of course, you didn't know that at the time. And now you've been fighting with Steinhoff to try and get either your company back or value for the company. There was an announcement today, which on the face of it seemed to be in your favor.
Alex, yes, I think the announcement that you referred to was put out by Steinhoff on SENS, relating to the judgment made by Justice Lee Boselek, in which he declared that two actions that Steinhoff took post the announcement of the accounting irregularities and the unlawful conduct as identified by Steinhoff, and he declared void the financial assistance that a Steinhoff subsidiary, Sipple, had extended to its holding company in order to, with the attempt to benefit what is termed financial creditors. Now, the financial creditors of Steinhoff, by and large, today are hedge funds that represent third parties, and mostly they deal in distressed debt. So they acquired Steinhoff debt at a very deep discount. They're hoping to get a full recovery on the original value of those loans, plus a 10% interest rate on an annualized basis. And Judge Boselek's ruling put that recovery for them very much in doubt. But it also confirms the one thing that was most intriguing to me, and that is that Steinhoff acted outside of the South Africa's Companies Act after the events of 2017. We still don't know if they acted outside of the scope of the South African Companies Act before, because Steinhoff sits on the PwC report that they don't release. But Judge Boselek's ruling says that the argument that the 2013 resolution that was also attacked was unconvincing, but the 2019 resolution definitely did not meet the required test, and therefore he declared it void.
It's very technical for those of us outside of the legal fraternity, or as deeply embedded in the whole story as you are. What really, unpack it for us? What does it mean that Steinhoff was actually acting even more badly than has been reported?
Yes, Alec, and I appreciate, that for us and others, this is our entire lives, and for your audience and the man on the street, it remains a fleeting episode, and one can only speculate about the intentions of those that are dealing right now with the Steinhoff fraud and addressing it. And I think in many ways, as the Zondo Commission regarding state capture deals with what happened in South Africa over the last decade, I think people would want to see that the same thing happens in the private sector, and arguably no place more relevant than Steinhoff. So what this judgment means is seemingly the intentions to get to a fair outcome, to make sure that all the criminals and alleged criminal activity is addressed, was not the intention of those that structured the proposed settlement agreement. And this ruling obviously is a big step back in terms of that settlement process, because Steinhoff would have to go back to the drawing board to see how exactly they can achieve what they were chasing with the settlement.
It's been an extraordinary story for those of us trying to cover it, because Steinhoff is now run by lawyers, and they couch everything in very careful legalese. And as a consequence, and of course, they're not prepared to talk openly. We've had many requests through to them to say, please just come and tell us what the heck is going on. And there's that kind of communication isn't forthcoming. Now, from your side, where you guys are sitting on billions of rands, literally, your life work, you and your partners in building up Tekkie Town, which has been wiped out, this must be doubly frustrating.
It is. It is. But, there's I think there's a lot of people that's negative about the South African system. And I guess it's easy to be negative about South Africa given what we've been through. But we are not, and we believe in the system, and we believe that there's a process, and often, and this has been an evolution, certainly for me personally. South Africa was built on resilience of people who wanted to do the right thing. And it took many years and decades actually to get to that point. And then, we've had another hiccup. And the Steinhoff episode is such an episode for me. I don't think it can just be swept under the rug because I don't think it would be good for the country. And we do live in a beautiful place, and we do conduct our businesses as entrepreneurs in this country, and we believe in it. So I think part of this process for me is to have that fixed. And hence the fact that we are not really interested in a settlement that benefits overseas financial creditors who stand to gain from the fraud that happened in Steinhoff pre-2017 by the company's own admission. So you, and I'm sorry, I'm rambling on a bit, but the truth is, if all of us knew the true state of affairs, certainly we would never have done our deal. I don't think the JSE would have allowed the listing of Pepco at that stage in September 2016. If Pepco was scheduled to list in March of 2017 after the event, or March of 2018 after the event, I don't think the JSE would have allowed it to proceed. So, because all those assets are tainted, Christo's Pepco assets, questions around the JD Group, which surfaced in this court case again. Certainly, our business was put in there for zero value to us, and I think it's a process that must run its course.
How's your legal process against Steinhoff going? In other words, to get your company back?
Yes. So, and Steinhoff refers to that in the papers many times. They say that no one that has brought legal action against them has got a case that's trial ready. And I think a lot of that has to do with the fact that Steinhoff has played a very resolute delaying game in terms of actually making sure that we don't get full insight into what happened pre-2017. So the trial readiness of various cases, including ourselves, is, in my view, delayed by actions on Steinhoff's side. So we've brought a liquidation application against Steinhoff. That will be heard from the 1st to the 3rd of September. And, we'll see what the outcome of that is. I think certainly Steinhoff would very, very much struggle to argue that they're solvent on the basis of assets that were obtained through fraud. I think Steinhoff would struggle to argue that they are solvent today. And I think that's the next big step. We firmly believe that if the control of the company is in the hands of a liquidator, you would have a much more open, transparent process, and that would be better for the country in a whole. And we believe that would be better for us because it would allow us to continue our litigation in the way that we want, which is ultimately the restoration of our business from Steinhoff via its subsidiaries, including Pepco.
And included in that, presumably, would be the release of the PwC report, which took years and millions of rands to compile, hundreds of people, hundreds of experts who were busy on the case. And that has been kept under wraps. For what reason?
I think it's increasingly clear that the reason why the report is kept under wraps, if you read it carefully, is that those financial creditors that stepped into the shoes of old debt holders post the fact have got a massive sway on the Steinhoff board at the moment. And it doesn't benefit their case at all to come out and say, we want to right these wrongs. I mean, the financial creditors which has really only been publicly identified now in our liquidation proceedings, are not South African entities. So essentially the benefit and the proceeds of this fraud would be distributed to via hedge funds in the US and Europe, to the likes of pension funds in the US and endowment funds in the US, etc. So it's interesting to note, for instance, that listed in the financial creditors is Cornell University, which is obviously not an entity from which Steinhoff borrowed money originally. They obtained that debt after the effect. And buying distressed debt at the risk that it was fraudulently obtained is a risk, and I guess that meets the risk mandate of these financial creditors. So we oppose that, and we think that the legal processes for everybody should run their course, not only civilly but also criminally.
So let's just get this right. You have people around the world who've taken a punt that the value of the Steinhoff debt is going to be worth more than they bought it for in the panic after the bombshell hit. Is that the correct interpretation here?
Yes, absolutely. That's exactly it. And those parties who sold the debt immediately in the aftermath of the announcement of the accounting irregularities and Marcus's resignation, etc., they recovered somewhere between 40 and 60 cents of the debt that was outstanding to them. They recovered it by selling it on to a third party. The third party is now claiming that they must be restored to 100% and that they must get a new interest rate of 10% per annum, which is very, very rich for mostly first world markets, as you would know. And in this process of Steinhoff settlement, those parties would be settled in full, plus they would get their interest. So we don't think that's a good situation.
And neither, presumably, after the judgment, does the South African judge.
Seemingly, in reading his judgment, he makes certain very, very strong. What is the right word? You must always remember, my first language is Afrikaans, so I struggle in English. But he makes very strong assertions regarding the status of Steinhoff's settlement proposal.
What does all of this mean for small shareholders in Steinhoff? We know there, again, tens of thousands of South Africans who still hold on to the shares in the hope that one day they're going to be worth something. Does today's judgment have any impact on them?
I think big time, yes. And it's a very good question, Alex, or Alec. Their case is obviously different to ours in that we had a direct contract with the company. They bought shares on the basis of what was promised, advanced, told, reported on. In an earlier judgment in 2019, often referred to as the Brain judgment, a ruling was made that those shareholders actually have no standing, and it's the company that should claim on the basis of the alleged fraud. But not only did Judge Bosselek give the class action participants under Hamilton a standing and the right to be in the South African court, he also, in his cost order, awarded them alongside Trevo cost against Steinhoff. And I think that's a very promising and a sign for the small shareholders and a fair outcome, to be honest.
And how will they benefit from this, though?
So the first is that the contingent payment undertaking that was provided to the financial creditors by Steinhoff subsidiary Sipple, the old South African entity that was listed here before it ventured to Germany, has been declared void. And as a result, theoretically, as it stands right now, before Steinhoff has revisited the proposal, there's more money to go around. I think that it's not far-fetched that there will be further attacks on the settlement process. That's why we believe a liquidation scenario is more beneficial to everybody, not only from a value perspective, but also from a truth perspective. And I think that Hamilton and Advocate Luderitz did a fantastic job in speaking up for the man on the street, in joining forces with Trevo to get this judgment that they achieved on Friday.
And what happens for the Steinhoff managers now, remembering that they are primarily lawyers from Worksmans, many of them, who've been drafted in to run a company that is now it's a little bit of a Stalingrad strategy, a bit like Jacob Zuma in certain respects.
Well, listen, your words, not mine. But the truth is that Louis de Preer, who runs Steinhoff, was with Worksmans. And before that, before he joined Steinhoff in 2017, he had done a lot of work for Steinhoff over many years. He also did a lot of work for some of those directors personally. So he does have a long, deep history within Steinhoff. And I think he's well familiar with the structures. And then Theodore Clark, who's the CFO of Steinhoff, is a very long-time Steinhoff man. And there is, even though I have no particular opinion on it, nor can I make an accurate assessment, there is a subset of the litigants that believe that they have incurred certain personal liabilities having passed this resolution invalidly, which is the resolution that Judge Boselek have voided now. So I think that might also come out in time. So we see, but I think it's a tough road. You know, the compensation of Steinhoff senior managers. It's always interesting to me, you know, because if you were seriously interested in saving the company, and if I was in that seat, I would have taken a lot of shares because then you believed in the value of the shareholder. But not a single Steinhoff director has bought any shares in the open market nor received shares for payment since 2017. And that is a big vote of no confidence in the future of the company for me. And the salaries relative to the size of the business is just enormous. I mean, the two top men there now earn 110 odd million rand a year between the two of them. It's an astounding figure.
Why do shareholders not do something about that?
Well, shareholders have voted against the compensation plan twice now. But the vast majority of Steinhoff's control now vests, for the time being, with the financial creditors who believe that they sat on all the security. Now, a very sizable portion of their security was punctured through Judge Boselek's judgment. And it would be interesting to see what flows from there.
So what do you think will flow from here, Bernard? You're very close to it, and thank you for unpacking all of this for us. But what do you think the next step would be in this whole process?
I can tell you what I would like the next step to be, but I can't necessarily tell you what the next step will be because I've become accustomed to being a slightly skeptical about this whole process, you know, because when news broke in 2017 and the whole world was misled that Steinhoff had appointed PwC to do a forensic report, we thought that this was actually a process that was designed to right the wrongs of the past. Then after more than a year, we were told that Steinhoff never appointed PwC, Worksmans did. That certainly wasn't disclosed adequately. And so to answer your question, I think it would be very, very good to have the entire history of Steinhoff out in the open. I would like to see those who allegedly contributed to the downfall of Steinhoff be charged. I would want them to have their day in court. I would want them, if they were guilty, to get a punishment that is commensurate with the crime. You know, and I think you and I might have discussed this before, but as a rule, what we've seen in our business, and I think it's the same here, people commit unlawful acts because in the first instance, mostly they have to. The second, because they found a way. The third is because the punishment, if court, is acceptable to them. And the fourth is they believe that they will not ever be found guilty. You know, so if we don't bring Steinhoff out into the open and we don't see the insights of the PwC report, and for instance, we don't have the benefit of an inquiry that shows what happened, this might just be swept under the rug completely. And in that regard, I'm very, very much energized by the actions taken by a company like EOH, who have taken decisive action against those that have been fingered in their particular case.
It's a little bit like the Zondo Commission is turning South African politics away from being a republic of no consequences. What you are suggesting or proposing is that there also are consequences for similar corporate malfeasance.
Absolutely, and hopefully we can agree on this. Because otherwise it speaks to those 4 pillars of wrongdoing that I just dealt with. If you can get away with it, and you're talking about one of the 10 largest frauds in the world's history, what stops the next person from seeing what loopholes are available to them when they need a loophole to present something that is not accurate at the time? So.
Thank you, Bernard Mostert, one of the co-founders of Tekkie Town, which was sold to Steinhoff for what turned out to be paper worth nothing. Okay.